5, 4, 3, 2, 1. The learned counsel for the petitioner submits that on the basis of the complaint, the learned court has taken cognizance under section 92 of the Factory Act 1948. He submits that the petitioner number 1 happens to be director of the said company firm. He draws attention of the court to the enquiry report and submits that the worker has also admitted before the factory inspector that he was provided with safety equipment like belt and helmet, and in spite of that the case has been lodged. On these grounds, he submits that there is no laches on the part of the management. However, the case has been lodged. On the other hand, the learned counsel for the state submits that accident took place in the premises of factory, and on inquiry the case found to be true, and that is why case has been lodged, and accordingly cognizance has been taken and there is no illegality in the order taking cognizance. In view of the above submissions of the learned counsel for the parties, the court has gone through the contents of the complaint case as well as the order taking cognizance. Admittedly, occurrence took place in factory premises and workman has also admitted that safety equipment has been supplied to him. Prima facie, it appears that this is not a case that the management has not provided safety equipment to the workman. To fasten liability upon the management, one is also required to look into sections 97 and 111 of Factory Act 1948, and there are certain obligations cast upon the worker also, and the safety equipment has been supplied by the management and not taking advantage of the same, the workman is also liable under section 97 and 111 of the said act. For ready reference, sections 97 and 111 of the said act are quoted below. Offences by workers. Subject to the provisions of section 111, if any worker employed in a factory contravenes any provision of this act or any rules or orders made thereunder imposing any duty or liability on workers, he shall be punishable with fine which may extend to 500 rupees. Where a worker is convicted of an offence punishable under subsection 1, the occupier or manager of the factory shall not be deemed to be guilty of an offence in respect of that contravention unless it is proved that he failed to take all reasonable measures for its prevention. Obligation of workers. No worker in a factory A shall willfully interfere with or misuse any appliance, convenience, or other thing provided in a factory for the purposes of securing the health, safety, or welfare of the workers therein. B shall willfully and without reasonable cause do anything likely to endanger himself or others. And C shall willfully neglect to make use of any appliance or other things provided in the factory for the purposes of securing the health or safety of the workers therein. If any worker employed in a factory contravenes any of the provisions of this section or of any rule or order made thereunder, he shall be punishable with imprisonment for a term which may extend to 3 months or with fine which may extend to the 100 rupees or with both. On perusal of these two provisions of the Factories Act, it is crystal clear that the scheme of the Factories Act is there. At the first instance, the occupier and manager must be prosecuted in terms of Section 92 of the Act. However, they may seek exemption under Section 101 of the said Act. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.